Hi, I'm Zach Áwerda, and I'm going to be talking about conferralism and police brutality. Let's start with the introduction, as that will explain the general outline I have up there in the corner, and we'll come back out to this main page as throughout the presentation. All right. When a police officer unwarrantedly brutalizes a person, typically we think that the police officer violated the victim's rights. However, I think this interpretation is incomplete. The situation is more dire. When a police officer unwarrantedly brutalizes a person, the victim ceases to have rights. The police, as agents of the state, deny victims natural personhood. And when we place this in the historical tradition of denying black Americans natural personhood, the demographics of police violence are unsurprising and racist. This paper seeks to provide a metaphysical explanation of this deprivation of personhood. I argue that metaphysical assumptions and legal policy dissolve the victim's rights in cases of police brutality. More specifically, I refer to Ásta's conferralist account of social categories to argue that in police brutality cases, the state institutionally deprives victims of their natural personhood by brutalizing them and leaving no meaningful recourse. Ásta's conferralist account is well suited to interpret Fourth Amendment violations because her emphasis on perception provides metaphysical tools that allow us to explain the lacuna that victims face. Alright, so that was the introduction, so let's dive into what is conferralism. So a good way of thinking about what a conferralist is when we think about Plato's question to Euthyphro. Is an action pious because it is loved by the gods, or do the gods love it because it is pious? Ásta uses this example in a lot of her papers, and the conferralist answer is an action is pious because the gods love it. So the gods confer piety through their love onto different actions. And so there are some properties that are obviously conferred. Take the property cool, for example. So like imagine people in a bar confer the property cool onto someone because this cool person is wearing sunglasses and a leather jacket and drives a motorcycle. In this example, the conferred property is cool, and all those other properties, wears sunglasses, wears a leather jacket, drives a motorcycle, serve as the base properties for the others to confer the property cool onto this person. Right. So the key is that in a conferralist account, the properties are given by others. So some properties are obviously conferred. You're only cool if others think you are cool. However, other properties are less obviously conferred, such as gender, race, and sex, and Ásta argues that all of these properties can be thought of as conferred properties. To make sense of less obvious conferrals, I want to talk about the property strike in baseball. Now, baseball provides a good example for this because the rules of conferral are codified, so it's easy to pick out exactly what's happening, where when you expand to like real-world examples, things get a lot messier. Okay, here's a quick story. Imagine a baseball game. The batter has 2 strikes and 3 balls. The pitcher throws a baseball with a particular and objective trajectory. The batter does not swing. The ball crosses the plate, and based on the umpire's perception of the ball, the umpire calls the pitch a strike. Now, we might think that the ball's trajectory is what makes a pitch a strike or a ball. So, trajectories that enter the strike zone are a strike, and trajectories that do not are a ball. However, the conferralist disagrees. The conferralist holds that the umpire confers the property strike onto the pitch. This is important because the umpire, rather than the base property, does the conferral, right? The umpire, not the trajectory of the ball, is what makes the pitch a strike. In other words, the trajectory of the ball does not constitute the pitch as a strike. The umpire's judgment and declaration are what make the pitch a strike. The conferral of strike hinges on the umpire's perception of the pitch's trajectory, but not the actual trajectory, right? So perception is really important. The gap between the base properties and the conferred properties is the central tenet of the conferralist framework. And this is just to emphasize that it's the umpire's perception of the ball's trajectory that matters. It's on the basis of that the umpire will either confer the property strike onto the pitch or confer the property ball. And if we look on the right side of this slide, what I have put here is a bunch of features that Ásta picks out of what goes into conferral. And for our purposes here, we want to know the top one, so the conferred property, right? So in this case, strike. And then the previous example, cool. And then the base property. So the base property is the basis for the conferral, right? So the leather jacket, the motorcycle, those are the base properties for cool. In the baseball example, the trajectory of the ball is the base property for strike. Now what's important is the conferral can happen even if the base properties aren't there, right? As long as the umpire perceives that the pitch's trajectory goes through the strike zone, then the umpire is going to confer the property strike, even though the pitch doesn't actually have that base property. And this is important. So it's important to notice that the conferred property, even though it's done on the basis of the base property, can separate from that, right? And that's the central claim of conferralism, or one of the important claims of conferralism. So hopefully that explains what the conferralist is up to. Now, Ásta distinguishes between two different types of conferrals. So one type of conferral, or one type of property that can be conferred, are what she calls institutional properties. So the distinguishing feature for an institutional property is that it's conferred by an institutionally ordained authority. So let's consider a couple examples, right? So in the baseball game, the property strike is an institutional property because the umpire has the authority to call the pitch a strike or a ball. A fan does not have this authority. So if a fan from the stand yelled, "Ball 4," their words would not perform the conferral ball. Additionally, an authority can only confer an institutional property in the appropriate context. A judge or a priest who has the authority to perform a marriage cannot go up to a random couple in a restaurant and pronounce them married, right? The priest isn't in the right context. So context matters with institutional properties. Communal properties are extremely context specific. They're a lot messier than institutional properties. So communal properties are conferred by a subject with social standing. For example, the popular kids in the cafeteria can confer the property loser onto me. Their social standing consists of the power they have from their status as popular. Being popular gives them enablements such as determining who is fashionable, who is cool, who is a loser. Now, as I already mentioned, communal properties are extremely context specific. So I'm a loser at lunch, but cool and talented at band practice that afternoon, right? Because all the band kids think that I'm cool. However, the situation can get even more complicated. For example, if the popular kids and the band kids both have social standing and both the band kids and the popular kids are at lunch, then whether I'm cool or a loser will be in tension and unclear. Now, these schoolyard examples are kind of a caricature and fairly low stakes. However, other communal properties such as gender and race have much higher stakes. Questions regarding who does the conferral, social standing, and conflicting conferrals become much more pressing in cases of race and gender. I touch on some of this in the next section. Before I move to the next section, I want to talk about a property. So, natural personhood should be thought of as an institutional property. So, natural personhood is a legal property. So, it's trying to pick out, what we typically think of when we think of as persons, right? Other human beings. And so we should think about the base property for natural person as being individual human beings. And we can contrast this with legal personhood, right? Because a legal person can include collective subjects such as corporations. And yeah, I just want to flag this really quick because it will play a big role later on in the argument. All right. So that's conferralism. So that's the first thing on the outline. And now we're going to jump over to categorical injustice. So categorical injustice kind of works analogously to epistemic and testimonial injustice. Here's an example directly from Ásta's paper, Categorical Injustice. So an engineer, let's call her Sandy, oversees a large construction project and has the institutional authority to assign work. The whole group shows up for the first day of work. Tom shows up late, and when he enters the room, Sandy says to Tom, "You will take section C." Tom says, "We'll see about that. I'll discuss it with the engineer." He does not realize that Sandy meant to be giving an order, because Sandy is a woman. A variation of this is such that he understands very well that he has been given an order, but he does not heed it. He does not respect the authority of the engineer because they are a woman. So there are two cases in this example. Let's look at the first. The first case in this example is the cognitional version of categorical injustice. In this case, Tom does not understand Sandy is giving an order as the engineer. Tom knows that Sandy is a woman, and on the basis of that jumps to the conclusion that Sandy is not the engineer, and thus doesn't take Sandy's order as an order, or at least as an order from a supervisor. And so what we have here is a type of uptake failure. Tom is failing to uptake Sandy's action as an order because of some stereotypes and background assumptions that Tom buys into. So in the second case, Tom doesn't show up late. He knows that Sandy is the engineer, and he understands that Sandy has just given him an order. However, he doesn't recognize her authority to give him that order because she's a woman. So this second example is not an example of uptake failure. Tom interprets the order as an order. Instead, Tom does not recognize Sandy's authority because she's a woman. And this next part is key. there is a mismatch in the constraints and enablements of Sandy's communal status as a woman and her institutional status of engineer. Ásta calls this second case the recognitional version of categorical injustice. And then I've put the formal definition of it at the bottom. To put this problem concisely, what's happening is Sandy's communal status of woman and what she is allowed to do as a woman, according to Tom, is overriding her institutional status of engineer, right? So it's the communal status and the institutional status are butting heads. That's what we should think of. That's what is happening in this case. And so Ásta gives two different kinds of categorical injustice. I think there are likely more. My point is I don't think that we should take these two different versions to be exhaustive. All right, so I want to consider a third instance of categorical injustice, and I'm going to call this institutional deprivation. And so we'll start with the definition, then I'll give an example. So the definition is institutional deprivation occurs when there is a recognition failure of an institutional status with no recourse within the institution. So here's an example. Consider the case where Tom refuses to recognize Sandy's authority as an engineer because Sandy is a woman. Let's expand this story. Imagine Sandy goes to her supervisor after Tom refuses to comply with her order. However, the supervisor refuses to reprimand or take any institutional action against Tom. Sandy then goes to HR, but they also refuse to help. Eventually, Sandy exhausts all of her institutional options for recourse against Tom, but does not receive any help. In this expanded story, Sandy has no institutional recourse against Tom. Tom's refusal to recognize her order stands without institutional challenge. And at this point, we should question to what degree Sandy actually has the status engineer, if she can't do the things that engineers are supposed to do. In this case, Sandy's authority is not just unrecognized by Tom, but she is deprived of her authority. So let's unpack this a little bit more. Sandy gives an order, and this order is refused by Tom. Right? Tom refuses to acknowledge her institutional status, or her authority to give him an order. And there's no institutional recourse within the company that she works for. And so what I'm saying is the property engineer, or Sandy's status of engineer, should be in question, right? She doesn't have the authority she's supposed to have. So at least to some degree, her status as an engineer is diminished. Now I'm going to derive a very strong conclusion from this. So I'm going to say that Sandy loses her status as an engineer in that instance. So a person who is institutionally deprived loses an institutional status in the instance of violation. So when Tom refuses the order, given that Sandy doesn't actually have any institutional recourse, in that moment, Sandy loses the property engineer. And I understand that this is a really strong position to take, and I don't quite have enough reason to back this up yet. And so I'm definitely open to bringing this down, but I'm going to start here and see how it goes as I work through this project. Okay. Now that we've talked about conferralism and categorical injustice, let's turn to the objective reasonableness standard that's used to assess Fourth Amendment violations. If a police officer uses violence, the objective reasonableness standard is used to determine whether or not that use of violence was reasonable or not. If it is reasonable, then it doesn't break the Fourth Amendment. If it's not unreasonable, then it does break the Fourth Amendment. And so here are some features that are important when thinking about the standard. One important point is that the intention and motivation does not matter, right? So if the officer has an evil intent, it doesn't matter as long as the officer acts as a reasonable officer would. And same thing with a good-intentioned officer, right? So if a good-intentioned officer acts in an unreasonable way, then that would break the Fourth Amendment. So that's the first point to keep in mind. The second one, and this is very broad, is that the facts and circumstances confronting the officer are relevant. So this just means, what's the crime that's potentially being committed? And if an officer pulls out their gun or uses a lot of violence for someone who is jaywalking or something like that, right, obviously would break the Fourth Amendment. But this is to account for just like the different circumstances of the situation, the potential crime being committed. Like, is it raining? Is it dark out? Like, what's going on in the scenario, right? And then the last one is that the reasonableness of an action must be judged from the perspective of the officer on the scene. So this third point where we're going to run into some trouble. And Christy Dotson actually really sums up why this feature is problematic. So Dotson says, the understanding of a reasonable officer have been shown to include both reasonable, racialized misperceptions and potential potential factual accounts all at once. This insensitivity to misperception in so-called facts is not only a problem at the level of perception, is actually a problem with the legal allowances and constitutionality of police violence. And so to some degree what Dotson is saying here is that by starting from the perspective of the officer on the scene, the facts and surrounding what was going on get tainted, right? And so if we think about the recent Breonna Taylor case, what ends up being important isn't what happened, aren't the facts of what happened. What's important is what the officers thought was happening, what the officers perceived to be happening. And Dotson's pointing out that this is bad, right? This legitimizes misperceptions that can potentially be racialized. So the objective reasonableness standard, or the ORS from here on out, reliance on perception makes conferralism a very relevant tool here. What I'm going to argue is that certain cases of police brutality are going to institutionally deprive people of natural personhood. And part of the reason this deprivation happens is because of how the ORS works and its reliance on perception. So the argument looks something like this. Natural persons have Fourth Amendment protection, right? A natural person is an institutional property. And so racist communal conferrals conflict with the protections of natural persons, right? And so this is one of those instances of categorical injustice, is we have a communal property that conflicts with an institutional property. But let's unpack this a bit more. So what do I mean by a racist communal conferral? And I mean perceiving someone as threatening or dangerous because of their skin color or because of their race. And this conflicts with natural personhood because a person who is actually not threatening or dangerous is protected by the Fourth Amendment, right? In a way that someone who, is actually dangerous would lose their Fourth Amendment protection to some degree, right? Because then it would be reasonable for the officer to use violence against someone who is actually dangerous. But when this misperception takes place and someone is seen as dangerous just because of their race, this conflicts with them not actually being dangerous and still having the institutional protections of a natural person. And so where the ORS really fails is it privileges the perspective of the officer. And that's where the misperception takes place. That's where the categorical injustice takes place, right? This is how recourse is eliminated or severely diminished, is that officers aren't seen as breaking the Fourth Amendment because their misperceptions are used in determining whether or not they acted reasonably. So recall that institutional deprivation occurs when there is a recognition failure of an institutional status with no recourse within the institution. And in some cases of police brutality, what we have is a mismatch between someone's natural personhood and their race, right? The officer can have a misperception or, right, see someone as dangerous because of their race, and that voids the protections that they have as a natural person. And so that's where the mismatch occurs, right? And what the ORS does is it privileges the officer's perception, but that's where the problem is taking place in the conferralist story, right? That's where the categorical injustice is happening, is that misperception. And so what ends up happening is the ORS will deem reasonable or use misperceptions in determining whether or not an officer acted reasonably. And what this does is it eliminates recourse. And so recall that I take a fairly strong position, which is if someone is institutionally deprived of a property, they cease to have that property. And that leads to some pretty big metaphysical repercussions. So what I'm going to conclude with is, in some instances of police violence, victims are institutionally deprived of their natural personhood. Not all of these cases will be racially influenced, but, right, so there could be instances of institutional deprivation that aren't based in race. Right? I think there are many cases where this does happen. But another important thing to keep in mind here is this is a metaphysical problem, right? This is a problem with what we think people are. When we compare this to, the history of the United States, where there was a time when black people weren't considered natural persons explicitly in the law, this to some degree I think falls into this tradition. While the ORS isn't explicit in its racism, what it does do is leave open an avenue for people to lose their natural personhood. And the demographics of who loses their natural personhood are unsurprising given the United States track record on these things. And I think this is an important thing to keep in mind, is there is a metaphysical problem here. And that is my presentation. And I'll throw the references up here, and